Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our civil number 15-33, Baker versus Kaplan. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel, as you know, you'll need to keep track of that time for yourself. We have read the briefs in conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the parties you represent? Counsel for appellant may proceed.
Good morning, Your Honors. My name is Sean Moore, and I represent the appellant Christopher Baker in this matter. With me at counsel table is Eileen Gilbride. There are three issues before the court today: whether Ashley Kaplan, or Mother, breached paragraph 5 of the SPA, a contract that was incorporated into the parties' divorce decree, whether the SPA, specifically paragraph 5 of the SPA, is enforceable, and whether this claim is barred by res judicata. I do not plan on addressing the res judicata argument today unless the court wants me to. I would like to reserve 6 minutes for rebuttal. The first issue is whether or not Mother, Ashley Kaplan, breached the contract, breached paragraph 5 of the SPA.
Just a general question. Is there a contract?
Yes, Your Honor, there is.
Did this become part of the decree?
No, this was incorporated into the decree but not merged, so it's still a separate contract from the decree, but is not merged into the decree.
How do we know it's the one as opposed to the other?
Because the contract itself tells you that it's incorporated. We have argued that it is incorporated, and Mother has argued that it is incorporated. Everyone, including the contract itself, is in agreement that the SPA has been incorporated but not merged into the divorce decree.
If it were merged, then your remedy would have to be under the decree, correct?
I believe so, Your Honor. That would be correct, but that's not the case here. It was only incorporated. So, as to whether or not Mother did breach the contract, there are four things that we have to consider here. First, whether or not Mother took an action. Second, to modify the joint custody agreement. Third, whether she had a good faith basis in one of the enumerated reasons for...
But on your first point, it's not taking an action, it's filing
an action. That's true, Your Honor. Whether or not she had a good faith basis for attempting to modify the joint custody agreement. And finally, that a court of competent jurisdiction made a determination that Mother did not have a good faith basis for modifying the joint custody agreement.
I'm sorry. Go ahead.
It seems to say that had no good faith believing such grounds existed, not for filing, but for determining that one of the grounds under 5.1 existed. Namely, significant health issues, a parent's ability to care for one or both of the children has been negatively impacted by physical or mental health, substantial noncompliance with the amended joint custody order and otherwise. So it's not merely a best interest of the child, but it's the parties had agreed that it's based upon the outline of 5.1.
Yes, I agree completely, Your Honor. It's whether or not Mother had a good faith basis that one of those four reasons that you mentioned existed. And that's not before Father could file this breach of contract claim, but that's before the breach of contract is determined. And that's partially why we're here. So a court of competent jurisdiction, as in this one, can make a determination that Mother did not have a good faith basis in one of those four reasons.
Why should we be the first determiner of her efforts, since that is a fact that the trial court may or may not have found in making its ruling?
Well, the trial court, Your Honor, decided that, the trial court held that that determination had to be made prior to bringing the action entirely, prior to filing the action. So this court would presumably be the first time that question would actually be considered on the merits. So
not a trial court.
We don't,
that's for people to testify, to look at the document and make a determination of whether she did have a good faith or whether it was just a bunch of hooey.
It's true that this is not a trial court, Your Honor, but all of the facts in this case are well known. Both parties agree on the facts completely. There's no discovery left to be
Well,
had.
be careful what you ask for here. If you want us to act like a trial court, you might not end up with the result you want. If there are some ambiguities and issues of fact, then you have a stake in the stake's not through the heart yet. So be careful what you ask for.
Well, it's agreed, Your Honor, but we believe that the facts of this case are completely agreed upon by both sides. We believe that the legal issues have been fully briefed by both sides.
Well, let me add. Oh, go ahead.
Well, I'd just amplifying on Judge Norris's point. If we think, I'm not telling you we think this, but if we were to think that what Mother was asking for was a mere accommodation rather than a modification that she expected to last from henceforth, you might rather have us not say that rather than leave it for the trial court to determine.
Well, that's true. If that's the case, then I would rather have you not say that. But if you thought that anyway, then we would lose on the breach issue, and this would be over anyway. So,
But are you? Maybe you're not. Maybe you shouldn't have lost. I'm not sure you should have won either.
okay.
I mean, for example, looking at the agreement, if either party files any action. Okay, what's an action? What's an action? Well, there's a legal definition of what an action is, and is usually considered a legal proceeding. Or did the parties mean more of an action in the sense that lay people speak, which is she took a step. She did something.
Well, I think that that what an action is described by the contract itself, and it's more the second definition, the lay people definition that you described, Your Honor. Paragraph 5.1 states, quote, "The following actions will not be deemed a breach of this agreement, the filing of any motion, pleading, or action requesting the court to modify." So when the contract was drafted, the word action was contemplated to include any motion, any pleading, any action.
How do we know that?
Because
How do we know that?
Because it's in paragraph 5.1, Your Honor. It says,
Isn't that a fact that a jury would ultimately have to decide if they were to agree with you that that's what it is?
well, courts can interpret contracts as a matter of law, Your Honor, and both parties are in complete agreement as to what the contract says word by word, vocabulary-wise.
Well, they agree that they were trying to bring a modification?
Oh, no, Your Honor. They just agree what the contract states.
Well, of course, we all can read it. We know what it says. I mean, it says what it says, but
Of course.
that's why we have lawyers and lawsuits. What do those words mean, and what do the parties understand? I understand your argument. It's a really good argument. But is that the only argument that can be raised about this language? And so maybe there is some lingering ambiguity that allows you to go back into the trial court and fight that fight?
Well, Your Honor, I think that there is enough in the record now to make a decision as to whether or not Mother filed an action to modify the joint custody agreement.
But she didn't file it, you did.
Well, no, she filed the response in the request to take the children. So Father, we originally filed the expedited motion to enforce Father's summer parenting schedule, and then Mother responded to that. But in Mother's response, she did not have to ask the family court to modify the joint custody agreement. She didn't have to ask the family court.
Could have just objected.
She could have just generically objected, or she could have said, you know what, I agree with the parenting coordinator. I have read the joint custody agreement. I realize that Father's summer parenting schedule should control in the summer of 2013. But instead, she asked the family court to modify that or to ignore it, whatever word you want to use, to go against the clear.
Your position as to the meaning of paragraph 5 is that even though she merely responded and did not file the action because she sought relief, that is the same as filing an action.
That's correct, Your Honor, especially because that relief was to modify.
But you could read this thing to mean we want this to stay out of court, and it's you that brought it into court.
Well, generally, the purpose of the provision was to help the party stay out of court and then compensate whatever party was brought into court. But specifically enumerated in the SPA is parties are allowed to bring an action into court to enforce the joint custody agreement and to enforce the SPA. And that's exactly what Father was doing here. The contracts are completely clear that Father was his summer schedule was supposed to control in the summer of 2013, and he was merely filing an action to enforce that in response to a letter from mother stating that she would, quote, be taking the children.
How does that work with the provision in paragraph 5.2 that said, should either party file an action to modify the terms without a good faith belief, then the damages or the penalty provision would take effect? How does 5.2 work with 5 and 5.1?
Well, I believe that 5.2 merely states the remedy for the breaches described in 5 and 5.1, Your Honor. So if mother, which in this case we believe that she did, if she took an action, filed an action to modify the joint custody agreement, then the remedies in 5.2 would kick in. So,
is there anything in we have inquiring minds like anyone else.
Sure.
Anything in the record that would suggest that the parties adhere to the terms of the agreement in the court's ruling?
could you restate the question, Your Honor?
Did the kids go to vacation with mom?
No, ultimately, the parenting coordinator and the family court.
Is that in the record?
Yes, Your Honor, that is in the record. That would be actually. I think
okay.
that's R7 Exhibit 11, if I remember
Well, it's
correctly.
true. The family court finally accepted the second recommendation of the parenting coordinator and agreed that father's provisions that allowed him to have final say when there's dispute control. So I think Judge Portley's question is, in fact, did his decision control, or did the kids end up going to Hawaii?
Oh.
Is that in the record?
And only answer if it's in the record, though.
I do not
Okay.
believe that is in the record.
Okay.
I mean, it could be that the most you have is an anticipatory breach, which may still get you somewhere. But if you went to court with your breach of contract action based on conduct by the mom that never happened, the most you'd have is an anticipatory breach. But you haven't really, nobody's even talking about that, right?
No, Your Honor. I mean, the breach of contract claim was filed after mother had already submitted the request to the court to modify the joint custody agreement to allow her to take the children. At that point, the breach had occurred, and therefore...
Saying the breach is taking the position in court.
Yes. The breach is trying to relitigate the compromises that had been reached in the divorce decree and in the divorce settlements.
So if her lawyer says, well, we intend to take the kids to Hawaii, and that brings you to file an action, but then she never takes the kids to Hawaii, that's still a breach?
No, Your Honor, because she would not have filed anything with the court to relitigate the already agreed upon compromises from the divorce decree.
Let me ask you something else of a broader, sort of a broader question.
Sure.
We have rules in the family court that reflect, I assume, a public policy that allows for modifications. And typically that's based on changed circumstances that persist.
Sure.
To what extent can parties contract out of that? We have a public policy that says, well, we're going to make the decree, make the best decisions for the children we can at the time of the decree, but things change, and we have to have a procedure for allowing one party or the other to come in and show us why things have changed such that we should make a different arrangement for the children.
Well, I have a couple responses to that, Your Honor. First, the contract did allow for that in the 4 enumerated reasons why you could bring an action to modify the joint custody agreement.
More limited than the rules of family court would allow.
Well, sure, but what...
On purpose.
Yeah, it's purposefully limited, but what it's trying to protect against is unilateral attempts to alter the agreements, not bilateral attempts to alter the agreements, which I would argue is different from what... under the contract, if both parties got together and they said, we think that provision X isn't working out for us, we want to change it, they could do that.
Yeah,
but this is
put it
trying.
a different way, if one parent thinks that the interests of the children require that they at least ask the judge to allow them to have a different arrangement, I mean, why shouldn't that be permitted? It's not all self-interest. I mean, hopefully each of these parents is looking out for the kids.
Well, presumably each of the parents are looking out for the kids. That's correct, Your Honor. But presumably, if one parent would have filed to modify the agreement for a non-enumerated reason that was somehow in the best interests of the child, I believe that is one of the catch-all provisions that is in, I believe it's paragraph 5.1, but I would need to go back and check on that, Your Honor. Now, moving on from the breach of contract issue, there's also the enforceability issue. And if you have any more questions on the breach of contract issue, please let me know. I just want to speak about this very quickly. I believe that the LaPrade case is very clear that any contract that is incorporated into a divorce decree cannot be subsequently collaterally attacked by one of the parties. And that's exactly what's happening here. The parties agreed upon the SPA. They incorporated it into the divorce decree. And now Mother is trying to say that the SPA should not be enforceable because it is a penalty. And the law is clear, and there's a public policy that ex-spouses should not be able to go back and renegotiate or relitigate issues that they had already compromised upon in arriving at the divorce decree.
Yeah, but you're enforcing it as a contract.
That's correct.
Can't you go back and if you make an agreement and you get sued under because of some provision in the agreement, you can't say that part of the contract's unenforceable under public policy?
No, the validity of the contract is established.
Sounds to me like your decree argument depends on a merger scenario.
No, not at all, Your Honor. The LaPrade case says as long as a contract is incorporated into the divorce decree, its validity is res judicata, and neither party can later attack it based on unenforceability or invalidity.
Decree is res judicata, but you're not enforcing the decree. You're proceeding under the contract.
I believe it says that the contract is valid as a matter of law, Your Honor. If you don't have any other questions, Your Honors, I'd like to save the remainder of my time for rebuttal.
We asked a lot.
Thank you.
Good morning. May it please the Court, my name is Scott Holcomb. I'm the attorney for the appellee, Ashley Kaplan, mother in this case. If I can, let me answer a couple of questions that you asked.
Yeah, I think you were, Mr. Holcomb, you're at least cognizant that we have some concern about the trigger having been pulled on a motion to dismiss here rather than this is not a summary judgment, it's not a trial verdict. And
absolutely, and so that's one of the questions I wanted to answer or particularly highlight, and let me start there. And that is, you just had it defined. The breach that they're alleging is not that Ms. Kaplan took the kids, but that she filed an action. Okay, so those facts are not in dispute. I mean, and those facts were established at the motion to dismiss level because there's only that one breach. That she filed an action to modify, and there was a determination that she did it without a good faith basis.
Just so we're not arguing about something that's not in dispute. Do you agree that she filed an action as it's determined?
No.
Okay.
We don't.
That's the issue.
You're saying that that's what the plaintiff is.
That's what the plea is, and that's one of the reasons why there is no fact issue precluding dismissal here. Because there's no set of facts that are susceptible of proof that would establish the breach that they've alleged. Because they've alleged a very narrow breach. And that's breach, the fact that that breach didn't exist is established by the family court record. Let me,
Forgive me. The family court record shows that when the parties couldn't agree, it went to the parenting coordinator, Judy Wolf, and she said, well, parties agreed. Odd years, father controls. Mother, not to be deterred, has her lawyer send a letter that basically says, well, so what? Mother's taking the kids to Hawaii. So father then has to file an enforcement action. She doesn't just remain mute. She then objects and asks for affirmative relief. She could not have been any clearer in asking for affirmative relief. And so we get the parenting coordinator back again in the saddle, who then concludes the same thing all over again, which the family court adopts. I will tell you, I'm having a really hard time understanding how what mother did doesn't constitute filing any motion, which under 5.1 is rather defined as an action. She asked for affirmative relief. Now, it came up in the context of basically a consolidated pleading, object and ask for affirmative relief, but she asked for affirmative relief. I don't, at a minimum, it strikes me that there's at least an issue of fact percolating in that as to what action means.
Your Honor, whether an action or not, the language could be clear.
Yeah.
But it not only has to be an action, but it has to be an action seeking to modify
Well, what was
the agreement.
The parties agreed in that odd years, father wins, even years, mother wins.
No.
And she basically said, I want to win in 2013, which is an odd year. I mean, she wanted that provision to be ignored. Furthermore, I would note the language doesn't just limit it to modify. It says, files any action in any court that challenges. Wasn't she at a minimum challenging the 2013 choice?
Okay, and that's an important distinction. I don't believe she was trying to enforce the agreement. There's a separate provision in the agreement. It's section 4.0, which requires both parties shall exert their best efforts to work cooperatively.
Well, I couldn't agree with you more. There is that provision. And it would have been nice if they would have acted in accordance with that provision, but neither side did. But at a minimum, then, is there some lingering ambiguity about whether that provision controls or whether what I would have thought clearly controls, which is if these people have a dispute over parenting time, odd years, jump ball goes to father.
Okay. And, Your Honor, two responses after that. One, I don't think there's a lingering ambiguity that allows them to enforce this penalty provision. And I do want to focus on part of that on the penalty, because that I think is a critical issue. But they keep leaving out the critical language of paragraph 5.1. The last part of 5.1 says, nothing herein prevents either party from filing an action to enforce the terms of the agreement or amended joint custody agreement, and such action shall not be deemed a breach thereof. And Judge Thompson, I think it was your question, made the point, nowhere in any of the pleadings filed by my client did she ask to modify the agreement.
Well, what was she asking for? Excuse me. She agreed father's choice would govern in a dispute over summer vacation parenting time in odd years. That could not be any clearer.
The first part of that, though, says that the parties cannot agree, and it provides for a procedure. If the parties cannot agree, they go to the parenting coordinator, which they did. And each time the parenting coordinator looked at this, she said the parties should agree. But if they can't, his request would comply. Each time we went to that, my client responded objecting to that, not seeking to change the agreement, not seeking to change that odd years his schedule would apply, but seeking to enforce the coordination and trying to get in the best interest of the children, which is important, an accommodation. She wasn't attacking his whole schedule. She's saying, I've got this. It would be in the best interest of the children, which is an overriding factor.
I guess maybe this is why we think there's perhaps some lingering issues of law, and that the Superior Court pulled the trigger too quickly in granting the motion to dismiss. Why go to the fuss and bother to agree that if the parties can't agree, then mother's choice governs in even years and father governs in odd years? Why bother with that provision if you can escape that by throwing out best interests and this and that and other provisions? I mean, why bother?
And this is an answer to one of the questions there earlier. The statutes defining family law, particularly ARS 25403A, provides the court will determine legal decision-making and parenting time either originally or on a petition for modification in accordance with the best interest of the children. So, for example, if father had come in and say, look, you have them for 1 hour, I have them for 1 hour. You can go whatever level it is. And you come in and say, that's his choice. But it doesn't deprive the overall policy that the party should be able to come to the court and say, that's not in the best interest of the children. And in fact, that's...
Well, then, isn't that then, and that's a good point. But then, isn't best interest an issue of fact that the court needs to address to determine whether, in fact, there has been a breach of this agreement?
No, Your Honor, because, again, even if mother thought that she was enforcing the agreement, they were trying to coordinate it, and the agreement also provides that the overriding factor is the best interest of the children. If she goes in and saying, I'm doing this to enforce the best interest of the children, okay, and which is what she did. And she never asked, again, modify. She's not seeking to change the agreement any time in the future. She's saying, I'm looking for this accommodation.
For her own schedule, because she booked these tickets back so much earlier. I mean,
it's because of family trips going on. But here's important. Let's skip to the money part. Let's get to the issue. Both sides agree. There has to be a determination by a court that she did not have a good faith belief, that she acted in bad faith in bringing these actions. Okay? There was no such determination. That determination should be made by the family law court, the one that where whatever action is filed is done. And the court did make that determination.
So you're saying that before they could bring the action, there had to have already been a determination of bad faith?
Correct.
The court didn't make a good. It addressed a request for attorney's fees.
Well, it also later, and we point out there's a February 6th, 2014 order on again, this is on father's petition to enforce the agreement and to hold wife in contempt, mother in contempt.
Where's that in our record?
It's in item number 7, the motion to dismiss, Exhibit 13.
Okay.
And that actually is quoted by Judge Udall in his order. And it's important that ruling was entered by the family law court after an evidentiary hearing on whether or not mother was violating the agreement, and specifically one of the provisions that were looked at, one of the causes was mother's failure to comply with the terms dealing with summer visitation. That's on page 2 of that order. And there was a full evidentiary hearing on that on November 18, 2013. All of this is in the record. Here's what and there's a lot of disparagement thrown at my client. You don't have to take their word or my word for it. Here's what the court held after looking at all this. And I think it's important, so I want to quote it. At trial, at that evidentiary hearing, Mr. Baker and his wife testified regarding the disputes that had arisen over the last year and a half, including this dispute over the summer parenting time, specifically referenced in the order. Ms. Kaplan testified as to her perceptions of the disputes. It is clear from the testimony and evidence that the parties have been all at odds over many parenting issues since the dissolution of the marriage. Based upon the evidence, however, the court cannot say that all the disputes have been primarily the result of Ms. Kaplan's actions or inactions, or from Ms. Kaplan's purposeful attempts to thwart Mr. Baker's relationship with the children. Some of the disputes resulted from Mr. Baker's conduct, inaction, or failure to communicate. Based upon these conclusions, the court cannot find Ms. Kaplan in contempt of the court for past violations, including specifically the one that they're claiming
that's
is
contempt.
Okay, but the court then went further.
Okay.
The court further finds that neither party acted unreasonably in this litigation.
Well,
and
okay.
The court further finds that neither Ms. Kaplan or Mr. Baker knowingly presented a false claim.
But I don't see that as being under this contract, which basically defines good faith as bringing an action under 5.1. It essentially puts a gloss on what good faith is. The fact that in the family court, the court did not find mother, or I guess in contempt, and did not find her taking unreasonable positions, certainly for an award of attorney's fees. I recognize that, and I accept that, but that to me does not quite fit within what these parties agreed when they decided that good faith would have certain parameters. And if an action fell outside of those parameters, it would not be in good faith.
And one of those parameters is any action to enforce any provision of the agreement.
We just come around full circle to issues of fact, don't we?
No, well, again, it also has to require a modification. She did not seek a modification. She did not seek a modification of the agreement.
Are you talking about modification in terms of the family law provision and the statutory terms, or is it modification under the parties' understanding? Because there are two things that are going on. You've got clearly the formal, and Judge Thompson talked about that, but then you've got a more nuanced, common sense request to just modify the summer schedule so she could have the family vacation.
Right. She is looking for an accommodation, and you can say modification, accommodation, whatever. I don't want to get into the language, but it's important. She was agreeing to the rest of the schedule, but she's saying this is in the best interest of the children. She put that before the court, which is both required under the agreement. She put it before the parenting coordinator, which is the procedure required under the agreement. She put it before the court, and her objection was filed pursuant to the order of the court, which said if you have an objection to the parenting coordinator, file your objection. She did all of those things. The actions, even if you consider those actions filed, which is the triggering event, were all in compliance with the provisions of the agreement. And she put it in front of the court, and the court and said it's in the best interest of the children to have this accommodation, not to change the provision that provides in odd years if they can't reach an agreement that father's schedule prevails. She is enforcing a provision that says that parties are to cooperate, which the parenting coordinator reaffirmed, and the court reaffirmed in its order as well, said the parties should agree. She was doing that. All of that's to at least enforce one provision of the contract, and that is not a breach. But if I may, let me turn to the penalty. The penalty.
Before you get to, can you tell me again the paragraph you identified that said the parties are supposed to act cooperatively?
Sure, Your Honor.
Because that's not in the supplemental agreement; it's in the other part of the agreement.
That is in the parenting agreement, the amended and restated joint custody agreement. It's section Roman numeral 4O, and it's referenced in our brief as well.
Thank you.
And so that provision's right there. Now, even if you found that those were fact issues, and I think, there's nothing to be added, I believe, to the court record and what happened in the family law court. Because, again, all this is based upon the filings in that court, and those filings, the relevant filings and the rulings of the court were all before Judge Udall when he made his determination. But this is also clearly an unenforceable penalty, and there's no ambiguity there. Notice if you look at the briefs and the arguments, there's no argument that this forfeiture of $1 million plus interest if somebody files an action to try to, let's say, even if it's fine to modify the agreements in the best interest of the children, that they forfeit $1 million interest that has any relationship whatsoever to the damages. They don't argue that, and they can't, because the agreement itself says this is a penalty. In the opening brief, they concede that the purpose of this clause was not to compensate anybody, but was to ensure certainty, predictability, and the end to litigation. That's their words. That's their description.
Make a good argument, but what struck me in reading this is that you have two people who, for reasons that only they can understand, have made difficulty after difficulty, disagreement, acrimony, and it is, frankly, looking at this, it was hard not to just as a third party get rather outraged over the behavior of both sides. And so what they do is they decide they're going to have a nuclear option in their agreement and going to have big ticket liability if the misbehavior that each side has exhibited continues. So maybe it would be a penalty if it involved my family, because we're not in the same league, but with these people and their level of acrimony, why doesn't it Why, you look at penalty and you have to say, oh, wait a second, they wanted to have the nuclear option so that they would stop the misbehavior and the acrimony.
Your Honor, that's the nuclear option, I think, is a perfect example of what it is. The nuclear option is what somebody has every time they put in a penalty. And the law and the public policy in Arizona is absolutely clear. The courts in Arizona will not enforce a penalty provision. And in fact, the exact situation...
My point is, and I'm sorry I wasn't very clear, what's a penalty to me may well not be a penalty in this case, in this agreement between these people.
No, it's a penalty either way. How much...
But an unenforceable penalty. Oh,
unenforceable
okay.
penalty.
Okay.
Whether you are rich or poor, and the law is absolutely clear, if the amount set beforehand doesn't have a relationship to the damages cost, not how much money you have.
Doesn't this have a relationship to the fact that they have so misbehaved, arguably, and made it so acrimonious, there is no meaningful way, except without the nuclear option, to bring these people to reality and to have proper behavior, to behave as adults?
That's exactly what a penalty provision is. And that's exactly what the court says it will not enforce. And in fact, in the Albans case, which I think is dispositive on this issue, they had exactly that same situation. The parties were fighting, they couldn't pay, and they agreed that if husband sought to change visitation, his waiver of child support would be taken away, and he would immediately owe back child support and attorney's fees. The court looked at that and had no problem saying that in this marital situation, and it was only $9,500. They said the purpose of that clause was exactly what you said. They didn't use nuclear option. They said ad terram. And that's exactly what you're saying. We want to put so much terror into that the parties won't do this.
Well, it obviously didn't work here.
It didn't work, but it also really, there's a level at which it shouldn't work. As Judge Thompson pointed out, there's an overriding factor of the parties have to be free to come back and be able to make modifications that what they believe is in the best interest of the children. And the gatekeeper on that is the court, determines whether it's in the best interest or not.
We could read this provision to say you both agreed that you would be penalized heavily if you ever did that. And you know, I have a problem with an agreement that says that in the face of a public policy that wants courts to be responsive to the needs of children and the honest requests from their parents to change the arrangements.
And I do too, and so did the court in the Albans case.
The person agreed to it too.
Well, and that's what the supplemental authority...
Presumably could enforce it against the ex-husband.
But they haven't. See, that's the problem. The clause says its purpose is to stop litigation. Again, ad terram, which is exactly what can't be enforced. It didn't work here. In fact, it created more.
Litigation can be abusive, but there's also a reason that we have courts.
Right, you have courts, but the law is absolutely clear. In contract action, the courts will not enforce penalties in any scenario. And this one doesn't even pretend it's not a penalty. It's called a penalty in the agreement. It says the purpose of it is to be an ad terram, to be a nuclear option. That's exactly what you can't. By the way, if I may, to answer one question, how do you know that this is not merged into the agreement? It's in the stipulated judgment, the orders, paragraph 2. It says the supplemental property agreement made a part hereof and incorporated as orders of this court herein by this reference, but not merged into the judgment, and shall be enforceable as a separate concurred. If I can, just real quick, the validity of the agreement's not that issue here. It's the enforceability. You can have CC&Rs that deed restrictions, perfectly valid, but they can have clauses that are against public policy. A person of a certain race or religion can't live here. The restrictions are valid, but they can't enforce it. And, by the way, and it said, I stopped too early. Not only does the clause in the stipulated judgment say that it's not merged into the judgment, but it says, shall be enforceable as a separate contract. It's subject to contract provisions, and it's absolutely clear that this is unenforceable under contract. Do you have any questions? Thank you.
Mr. Holcomb. Can we add a couple of minutes to their side in case they need them? 2 minutes, please.
You've got a lot to chew on.
Yes, I will try to address everything, Your Honors. We'll see how successful I am. So right off the top, I want to address something that's not really relevant to any of the arguments, but something that Mother mentioned multiple times in the answering brief and a couple times up here, and that was the best interest of the children. Mother has claimed multiple times that she was acting in the best interest of the children, but when Mother brought the request to take the children on this vacation, the family court sanctioned her for that action. And just as a general observation, family courts generally don't sanction people for acting in the best interest of the children. So, moving on to the...
For doing what?
For attempting to modify the joint custody agreement, Your Honor.
Where is that in the record?
That is, that's the order... that's the order rejecting Mother's request to take the children. That would be R7 Exhibit 11, Your Honor.
A monetary sanction?
Yeah, it was attorney's fees, Your Honor. And that's the attorney's fees that Mother was claiming race judicatas out this breach of contract claim.
The court in that determination found no one took unreasonable, but still awarded father attorney's fees.
That's correct, Your Honor.
That could be under the statute based on the financial positions of the parties, correct?
It could be, Your Honor. And the order does not tell you which of the two it goes to.
That's not necessarily a sanction.
That's correct.
Just a fee provision.
That's true. It's not necessarily a sanction. That's true. So moving into the breach of contract analysis, Mother claims that she did not attempt to modify the contract because she was acting to try and enforce the cooperation clause. But I would note that Mother never made this argument at the family court or at the trial court level. One would think that if this was her actual motivation, she would have mentioned this somewhere, anywhere else. But she never mentions this anywhere. Moreover, her actions go against the fact that she was trying to enforce cooperation. She sent a letter through her attorney to Father saying Mother will be taking the children over these 2 weeks, which is...
Mr. Moore, I may have missed that, so let me make sure I understand what you're saying.
Sure.
You're saying that Mother never argued in either the family court, insofar as we have the record, or in the superior court, that she was attempting to
enforce the cooperation provision of the joint custody
never
agreement.
relied on that provision.
Never.
Okay.
Yeah. And one would imagine if that was her true intent, her true purpose in filing this action, she would have mentioned that somewhere. Now, there was a lot of discussion about whether or not Mother had a good faith basis for bringing this action. And it's important to note, and Judge Norris mentioned this a bit, that this is not good faith in the general legal sense. It's whether or not Mother had a good faith basis that one of the 4 bases spoken by Judge Portley existed. And that simply is not the case here. Mother outright admits in her brief that she did not have one of those 4 bases. So at the point that that's true, this court can, in fact, rule that she did not have a good faith basis to do that.
Now, you've heard my kind of concern about these kinds of provisions.
Sure.
Are there cases that say that parents can reach agreements regarding their children that are immune from ever being discussed in further court proceedings except with a penalty of losing a lot of property? Are there cases that say this is okay?
I mean, well, I would argue that the LaPrade case and all the cases that come before and after it would say that. They say that contracts that have been incorporated into divorce decrees have their validity predetermined and that they are res judicata. Essentially, the determination you're trying to make was made by the family court. The family court looked at the contract, determined that the contract was fair and in the best interest of the children, and now that validity is res judicata.
I'm not saying this is the case, but let's just say it were the case here that no reasonable person could believe that what the mother was proposing for the children with other families and all this stuff was absolutely the best thing for those kids, and what the father was proposing was nothing. I mean, your reading would prevent the reasonable mother from ever going to court to ask a judge to determine whether that were the case. I'm not saying that's it. I know there's 2 sides to this, and there always are. But should we have a provision that says a properly motivated parent looking out for their children's best interests couldn't at least go and ask the judge, look, is it okay if I do this one time?
Well, that's what the parenting coordinator is there for, right, Your Honor? So the parenting coordinator, which there's one of them and it's changed identities a couple times, but the parenting coordinator looked at the situation, looked at the agreements, looked at the actions by both parties, and determined that it would be in the best interest of the children to follow the agreements that had been reached in coming to the divorce decree. Now, mother didn't like that, which is why she then tried to get this
Really
changed.
say that what the mother was proposing wasn't the best thing, just said, if they don't agree, it's better off we just stick with the agreement and not get into this.
True, and I would argue that
It was not really a full-on approval that the father's plans were better than the mother's.
True, and I'm not certain that it was the plans that was the best interest of the children. It was the avoidance of continued litigation over previously agreed upon items and contracts that was in the best interest of the children. And the fact that mother had to go dredging this stuff back up is what's now harming the children, because we have to go through this process and stuff all over again. And that's the entire point of paragraph 5, is to avoid this relitigation, which is harmful for everyone. Now, moving on to mother's argument that there needed to be a prior finding of no good faith belief. That's just simply impossible. It results in an absurd result because there's no other time that father could have gotten that finding than at the trial court level. Mother successfully argued that the family court did not have jurisdiction to make that determination, and the contract is clear that there needs to be...
Couldn't that have been appealed? Couldn't that determination been appealed from the family court that it didn't have jurisdiction when, as a superior court, it cleared it does have jurisdiction?
Well, I suppose that could have been appealed, Your Honor, but mother successfully argued that the family court did not have jurisdiction. I believe that mother would maintain that argument now.
But what about then Mr. Holcomb, and he has a good point, that the Exhibit 13 to Record on Appeal Number 7, which is the contempt determination, that the court essentially addressed mother's conduct and found that she had not acted in bad faith.
Well,
words to that effect.
Well, there are a couple responses to that, Your Honor. First, that was over a number of disputes, and nothing said in that was specific to this particular dispute. But second, the determination of good faith isn't good faith in general, or whether or not the parties acted reasonably. It's whether or not mother had a good faith belief that one of those 4 enumerated reasons existed, and she admits that she did not.
We get that part.
If Your Honors don't have any other questions, I think I'm out of time. Thank you.
Thank you. Thank you both for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.